Today I want to talk about access to environmental justice. I want to unpack what those concept of environmental justice is, and I want to talk about how effective the law is in providing access to environmental justice, or perhaps how ineffective it is. Because we have as a goal that we want to achieve access to environmental justice, and we say it in various ways. But the problem is that we really don't see what it means and how we're going to get there, and what are the obstacles and how we've got to overcome it. So let's go through, firstly, what is environmental justice. Now we can break it up into three basic concepts. The first is distributive justice, the second is procedural justice, and the third is recognition justice. Let me just introduce each of those topics, then I'll go into much more detail about each of them. The first is distributive justice. Now, distributive justice is concerned with the distribution of environmental goods or benefits and environmental bads or the burdens or costs. So access to environmental justice involves ensuring a just distribution of environmental goods and bads between the members of the community of justice. The second one was procedural justice. Now, procedural justice is concerned with the ways in which decisions are made and who is involved and who has influence in making those decisions. Now, procedural justice is provided by the law, giving procedural rights to firstly, have access to environmental information. Secondly, to participate in environmental decision making. And thirdly, to have access to review procedures before a court. The third concept was recognition justice, or access to justice's recognition. Now this is concerned with who is and who is not given respect and is valued. And access to justice's recognition is promoted not only by giving substantive and procedural rights, but also by affording recognition to all members of the community of justice. So let's now go into a bit more detail about each of those three concepts. The first was distributive justice. Now, in order to achieve distributive justice, we need to address four questions. The first is, who are the members of the community of justice? The second is, what is to be distributed? What are the benefits and burdens that are going to be distributed? The third is, what criteria are to be applied in making that distribution? And the final one is, what distributions are necessary to achieve functionings? Let's go through each of those four questions. The first is the community of justice. Now, the concept of a community of justice is going to be applicable to each of the three types of justice that I'm dealing with. So one was, of course, the distributive justice, the next was procedural justice, and the third was recognition justice. But when we're talking about the community of justice, we're looking at who are the recipients of justice. So for distributive justice, it's who are the recipients, or who are the claimants first, and who are the recipients of the distribution of those environmental benefits and burdens. For procedural justice, the community of justice comprises those entities who have access to information, who can participate in decision making, and who have access to justice. For recognition justice, it is the entities who are entitled to recognition. Let's come back now to looking more particularly at that community of justice for distributive justice. And how might the law affect the community of justice? Well, the laws regulating or resulting in this distribution of environmental goods and benefits, bads, affect the community of justice in two ways. The first is it confines the membership of the community of justice. And the second is it affects who within or outside that community of justice receives the environmental goods and benefits. or goods and bads, sorry. So let me start with that second way, and then we'll come back and address the first way. So the second way is the distribution of environmental goods and bads. Now what we see in the community, with the laws, is that the environmental laws, as a general rule, are biased towards consuming uses instead of non-consuming uses of the environment. So just think about, what are consuming uses? Well, they're all the uses that take the environmental resources. So the mining, the logging, the extraction of water, the extraction of any materials from the earth. That's a consuming use. What's a non-consuming use? A non-consuming use would be a national park where people can go and visit it, appreciate it, but they don't take anything from the national park except photographs and memories of that national park. But what we see in the structure of environmental law is it's all biased towards the consuming uses rather than non-consuming uses. Now, environmental laws, as a general rule, have this structure. They start with a prohibition. They say that somebody should not do something to the environment. You shouldn't log, you shouldn't mine, you shouldn't pollute water. Then it comes up with the concept that you can relax that prohibition by way of a permit or approval or a consent, which authorises the doing of that consuming activity. So what happens is environmental laws are orientated towards getting approvals for consuming uses. However, there is no structure for getting approval for doing a non-consuming use. So if you're going to leave the environment alone, you don't need to go and get an approval for that non-consuming use. So what we see is that this leads to a shift in how decisions are made. First, the next thing that happens is it changes the burden of proof. So the burden of proof will be on the non-consuming users to establish that conservation rather than consumption of the environment should occur. Remember, I said that the structure of environmental laws is that you need an approval to do a consuming use. If somebody doesn't want that to occur, they want conservation instead of consumption, they have to be an objector and they have to oppose the doing of that activity. So the burden of proof ends up shifting towards the people who oppose consumption rather than the people who promote the consumption of the environment. The next thing we see about the laws, as the third point, is that decision-making under each law is isolated and reductionist. It doesn't consider the cumulative impacts of decisions under other laws. So if you're applying for an approval under, say, pollution laws, say water pollution laws, then that decision about whether or not to grant the pollution licence is done in isolation from whatever other activities or approvals might be required. So, for example, if it was a mine that needed the water pollution licence, then it also might need a mining licence. Yet, when they're considering whether to grant the water pollution licence, they don't look at how that mining licence decision might be made. They also don't consider what other pending applications might be before the decision maker. Come back to the water pollution licences. Don't look at what other water pollution licences might be granted, to look at the cumulative impacts of granting all of those pollution licences. And the other thing it doesn't do is look at future licence applications, where we haven't yet put them in the system, but they may come in the future. So there's not a consideration of that cumulative impact going forward. Now, why does that matter? Well, what happens is it downplays the environmental costs or burdens of the consuming uses. And that leads to a skewing in the decision-making process so that it favours the grant of the licence or approval for the consuming use. The next one, the fourth point I want to make about the laws and this distribution of environmental goods to consuming users, is that laws don't mandate the full internalisation of these external environmental costs of the consuming uses. Now, an externality is known in economics. It's a simple concept. If we had a factory which is belching out air pollution, then there is a cost, not to the company because it's polluting for free, but there's a cost to the surrounding countryside and villages who suffer from the air pollution. And if you internalise those costs, then the polluter would have to pay for preventing that pollution in the first place, or compensating for any health effects or environmental effects, and have to pay for the remediation of the environment if it's been harmed. That would be an internalisation of those external costs. But what we find is that laws, as a general rule, don't mandate the full internalisation of these external costs of the consuming use. Why does that matter? Again, it skews the decision-making. Because in that cost-benefit analysis, if the costs have been downplayed, but the benefits have been promoted, then when you compare the two, the benefits are more likely to outweigh the costs, and therefore the consuming use will be approved. So by this failure to internalise the external costs, it leads to a skewing towards approval of the consuming uses. So that's one way we see that the law has this problem in the distribution of the goods and bads within the community of justice. Let me come back to that first point I wanted to raise about who are the members of the community of justice. Now, when we look at our laws, they generally only include a limited class of members within the community of justice. Who is that limited class? Well, firstly, it's present generations of human beings. We don't get future generations brought into the community of justice. But secondly, what we don't have is non-human nature. Whether it be present generation or future generation, they're not included within the community of justice. We can immediately see what the problem is. We're dealing with distributive justice, that is the distribution of the environmental benefits and bads, and if we have a significant component of people and nature that is not included in the community of justice for distribution purposes, then they will not be considered in that distribution. I mentioned that the laws generally only deal with present generation of humans, they don't deal with future generations of humans, and they don't deal with non-human nature, whether present or future. So this is a problem with a failure to take into account intergenerational equity. Now, concepts of intergenerational equity involve perhaps three aspects. One is conservation of options, the second is conservation of equity, and the third is conservation of access. I won't have time to go through and unpack each of those. But what we do find is that environmental laws fail to implement any of these three intergenerational equity principles. So we can see that the laws don't allow for the current non-distribution of environmental goods to benefit future generations. Now, we know a very common way of talking about intergenerational equity is that it's about satisfying the needs of the present, but without denying the needs of future generations, that the future generations can be able to satisfy their needs. But to do that, we actually have to conserve. We have to put aside those environmental goods which can be used to satisfy the needs in future. But remember, I said that you can't apply for an approval for conservation. You can only apply for an approval for consumption. So the legal system just doesn't allow for present generation making an application today to conserve, not for themselves, but for future generations. So that's one of the legal problems. The next thing we see in the laws is that generally there is an inadequate consideration of intergenerational equity. But it's one thing to consider, it's another to actually implement it. And what we find almost universally in the laws is there's no specific duty on the present generation of decision makers to achieve intergenerational equity. Not just consider it, but actually achieve that outcome. That's what we don't find. I've also said that the community of justice excludes non-human nature. So they can't make a claim for distributive justice. They can't claim for the distribution of environmental benefits, such as the river making a claim for environmental flows. But they also can't protest the distribution of environmental bads. All the burdens that nature suffers, they can't object to that either through the decision-making process or ultimately, as I'll show, through the courts. So what we can see is that insofar as non-human nature can be recipients of the human deliberations about distributive justice, it's distributed the environmental burdens and not the benefits. And again, the reasons flow from what I've been saying. You can't have an approval for the non-consumption or the non-distribution of environmental resources. So nature, if you've got an endangered ecological community, wants that community to stay as it is. It wants the inputs, whether from water or the biota, to remain as it is. They would want non-distribution, a non-consumption of those resources, but it can't do so. And there can't be, insofar as sometimes you see an approval granted for an offset. That is, if there is a consumption of environmental resources that are needed by non-human nature, then they say, well, we'll offset it by providing some other resources somewhere else. That, in fact, is illusory, because there never is a positive distribution of environmental resources. If you have two areas of habitat for an endangered species, if you consume one of those areas by clearing the forest, for example, and on the condition that you set aside the other area, you don't actually offset it at all. What you started with two areas and you now got one area, and so there is a net loss. There is not a true offsetting. That'll suffice for talking about the community of justice. Let's go to the second question that I said we need to look at to work out whether there's been distributive justice, and that are the environmental goods and bads that are to be distributed. Now, when we think about environmental benefits and burdens, they depend upon who is the claimant and the content of the claim. So if we just think about what would be an environmental benefit for non-human nature, it might be that there be flooding, regular flooding. For example, many Ramsar wetlands depend upon overbank flooding in order to sustain the ecological health of the wetland. But that might be viewed as a burden for humans, particularly human consuming users. So because the flooding could cause damage to property. It might lead to loss of water, which could be used for consuming uses such as hydropower, or for irrigation, or for stock or human consumption. And so you can see that what's viewed as a benefit to non-human nature might be seen as a burden for humans. So we do need to understand what is to be distributed. Let's come to the third point, and that is the criteria we're going to use for the distribution of the environmental benefits and burdens. Now, generally, we could group the criteria in three categories: goal-based, rights-based, and duty-based. Now, goal-based criteria take a goal, such as improving the welfare of the members of the community of justice, as the fundamental for the distribution. Rights-based criteria take a right, such as a right to liberty, for example, as fundamental. While duty-based criteria take some duty, like the duty to obey some commandment or moral quality, as fundamental. Let's just go and see a little bit more about what those goal-based, rights-based and duty-based criteria might look like. So let's start with the goal-based criteria. Now, one of the very common criteria comes in utilitarianism. So it's a consequential ethic which is used as a criterion for the distribution of goods and bads. So hedonistic utilitarianism, which was championed by Bentham, would look at what is the greatest happiness for the greatest number. That's the goal that you're trying to achieve. There's variations on utilitarianism. So one has been suggested as biohappiness utilitarianism. And so Bhutan, for example, has a gross happiness index. Professor Nick Robinson has suggested a biohappiness criteria for distribution. Or we can go to economics. We can use economic utilitarianism, such as advanced by Posner. And here we're looking at the maximisation of society's total wealth. Another one would be social utilitarianism, such as Yering put forward. And this would be a maximisation of social wealth, but by controlling individual purposes and shaping them to be consistent with the social purposes. Let's go to rights-based criteria. What might be some of the rights-based criteria? Well, Rawls put forward justice as fairness. Dworkin put forward a concept of individual rights. Bell has put forward principles of equality, and there's variations on that, what principles are. One might be the distribution on the basis of some criterion, such as the spatial area or per capita. Or we could add to that principle of equality a guaranteed standard. So this would require the removal of inequality, but also ensure a standard of environmental quality for all, such as a basic standard of air or water quality. Or we could have a guaranteed minimum quality with a variation above that, depending upon personal income and spending choices. So there are variations on our principles of equality. Right? So they're all based on rights. Now come to duty. What might be some of the duty-based criterion? Well, remember that a duty-based criterion, it sets a morally accepted standard of behaviour, and it judges the distribution by reference to that morally accepted standard of behaviour. Now, Aldo Leopold put forward a land ethic, and I'll just say what it is. A thing is right when it tends to preserve the integrity, stability, and beauty of the biotic community. It is wrong when it tends otherwise. Or Baxter put forward a principle, and I'll say this one. We must do right by other life forms by recognising their claim to a fair share of the environmental resources which all life forms need to survive and flourish. You can see in those two that I've just articulated, there is a morally accepted standard of behaviour, and that's used as the criterion for the distribution. Now, if we look at the law, we can see some different criteria used. A duty-based criterion might be seen in the principles of sustainable development. So if we think, I mentioned the principle of intergenerational equity. So the present generation should ensure that the health, diversity and productivity of the environment is maintained or enhanced for the benefit of future generations. See, that's a duty. Or take this one, the polluter pays principle. Those who generate pollution and waste should bear the cost of containment, avoidance or abatement. So that's another duty. So we can see some of these duty-based criteria in the ecologically sustainable development principles. Now, I've said that one of the problems is the community of justice doesn't include future generations of humans, and it doesn't include non-human nature at all. What if we were to expand that community of justice? How would that affect the criteria that we use for the distribution? So let's come to the goal-based ones. Well, we could pick environmental quality goals. So for example, in the distribution of environmental resources for stream rehabilitation. Or we could apply the principle of utilitarian equality, where the goal is to maximise overall catchment health. What about if we used rights-based criteria? Well, you would have to consider the needs, the interests, the vulnerabilities, and the integrity of non-human nature, both in the species and particular communities. What about for duty-based criteria? Well, you could apply a duty such as Aldo Leopold's land ethic, or you could have causal responsibility, such as is found in the polluter pays principle or the user pays principle. My fourth question was about the capabilities that are needed for the distribution. Because achieving distributive justice is not only about ensuring the distribution of the primary goods that are just in themselves, but also ensuring that those distributions enable the individuals and the communities involved to lead fully functioning and flourishing lives. So this is the capability approach championed by Sen and Nussbaum. It's concerned with what is needed to transform those primary goods into a fully functioning life, and conversely, what interrupts that process. Could we use the capabilities approach for non-human nature if we included non-human nature in our community of justice? Yes, we can. So we could do it in this way. We'd be asking what distributions are needed for fully functioning and flourishing individual organisms or populations or communities, as well as larger living systems such as ecosystems and catchments. And conversely, we'd be looking at what interrupts the capabilities and functionings of these entities of non-human nature. Now, coming back to looking at the law, I've shown you a number of problems with the law at the moment in the way in which it deals with distributive justice. Let me just come back and pick up a few more. So for goal-based, we see these problems. Statutory objects, or objects in statutes which say what the purpose of the statute is and meant to govern the exercise of decision-making under the statute, tend to be inadequate in setting or prioritising environmental goals over economic or social goals. This is also true in the list of relevant matters that a decision maker must take into account in making the distributive choice, the distribution of environmental benefits and burdens. Again, what we see is they're inadequate in prioritising environmental goals. What about rights-based? Well, the statutes prioritise the rights of human consuming users, and that's over the non-consuming users. For example, it's quite common to find that there are existing or non-conforming rights. That is, if somebody has been consuming the resources from the environment at a time when it started lawful but has become unlawful, they have a right to continue to do that. And so there's a prioritisation for those existing uses. Or we can see guarantees in legislation that there should be certain resources allocated. So we see it in forestry terms for the distribution of rights to log forests. And what we also see is that there is an inadequate consideration of non-human nature. Very rarely we see some consideration of non-human nature. For example, in water management, there may be a principle for water distribution that requires a certain degree of environmental flow. For duty-based principles, duty-based criteria, we do see them sometimes in the statutes, mainly to do with the principles of sustainable development. But generally we never see a duty that you must actually achieve sustainable development or sustainability. It's merely a consideration. That's all I wish to deal with in distributive justice. That was a big topic. I'm now going to come to procedural justice. And so procedural justice is relevant because when we think about the concept of justice, it involves not only a fair or just distribution to achieve a just outcome, but we're also concerned with the procedure by which that distribution occurs. And so we want a just procedure for the distribution. Now, procedural justice generally can be seen to involve three basic concepts. Firstly, the access to environmental information. Secondly, public participation in environmental decision-making. And thirdly, access to justice by review procedures before the courts. Now, what are we dealing with in access to information? Well, we see it coming through in Principle 10 of the Rio Declaration on the Environment and Development. We see it elaborated on in the Bali Guidelines on Rio Principle 10, and we see it in the implementation guide that was done by UNEP to explain those Bali Guidelines. We see it in the Aarhus Convention, for example, Articles 1, 4 and 5. Now, the adequacy of laws in providing access to information involves these components. Firstly, the environmental laws might contain public notice and comment. It might require a register of applications and approvals. There might be right-to-know laws. There might be laws that require the state of environment reports or agency annual reports. There may be laws requiring reporting of pollution incidents. There may be freedom of information laws. And there may be laws entitling requests for reasons for administrative decisions. And they are all ways in which we see the laws giving content to this first component of access to information. The second component is public participation. Again, we see it in Principle 10 of the Rio Declaration. That's elaborated on in the Bali Guidelines and the implementation guide on those Bali Guidelines. We see it in the Aarhus Convention, Articles 1, 6, 7 and 8. So the adequacy of the laws in relation to public participation. Well, generally we see that the public participation comes later in the process. It ought to be early in the process, but it tends to come once there is a fully formed application under the laws for approval to engage in consuming uses. There rarely is proactive public participation. Often there's not provision of information that is understandable and timely. And often it's not meaningful. The public participation would be on rather tokenistic in the way in which the public can participate. There may or may not be opportunities to review the public participation by access to a court. We also tend to find that public participation is skewed towards the approval of particular projects rather than in strategic plan and policy making. Public generally don't get to participate at that stage. And what we could need to improve is much more education and capacity building for the public to meaningfully participate. And of course what we do see is that the non-human nature doesn't get to participate at all. So because it's excluded from the community of justice, they don't get to participate at all. So humans who are of the current generation can participate through these processes. but non-human nature can't, even through a proxy. So how might we improve that? Well, we could do it in a number of ways. We can recognise that non-human nature is able to communicate, except it can't communicate through human language. But it can communicate by sending signals which show disruptions to the integrity of nature. So we can all look at a polluted stream when we start to see the fish dying, increasing algae in the river. That's a signal to us that the ecological health of that stream is suffering. And so if a human could take that information and put it in, then that would be a way of participating. But humans can also participate on behalf of nature through proxies, or you can appoint legal guardians or spokespersons. So in certain areas, for example in New Zealand, in Victoria, in the state of Australia, and in India, rivers have been given rights to be represented by humans to participate in processes. The next one is the access to justice. So this is involved with coming to the courts or tribunals. Again, we see it coming through in Principle 10 of the Rio Declaration. It's in the Bali Guidelines, in the Implementation Guide, and it's in the Aarhus Convention in Articles 1 and 9. So when we try to evaluate the adequacy of the laws in ensuring access to justice, we need to look at these factors. Firstly, the extent to which the public are able to challenge decisions in the court. This requires liberal standing rules. There needs to be timely review by the courts. Delay is a denial of justice. There needs to be affordable review procedures. There has to be prompt, adequate and effective remedies. There has to be enforceable decisions and orders. There's got to be adequate information about court procedures, and there has to be publicly available and accessible court decisions. Judges and lawyers involved in the process have got to be knowledgeable about the environment and environmental law. And there's an advantage in having alternative dispute resolution mechanisms. So all of those things need to be done if we are to improve access to justice. And the final topic is justice as recognition. Now, issues of recognition are distinct from, but closely connected to, issues of distribution and procedure that I've been dealing with so far. The lack of recognition, both in the social and the political realms, can be demonstrated in various ways. It can be done, for example, seen in insults, in degradation, in stigmatization and devaluation. And that lack of recognition or misrecognition inflicts damage, and it constrains both individuals and communities, and it leads to both procedural and distributive injustice. Procedural because it inhibits the effective participation in the polity, so it's procedural injustice. And it leads to inequalities in the distribution of the environmental goods and bads, and so it leads to distributive injustice. Now, misrecognition can be seen to be an injury to the institutional or the social status of individuals or communities. And there are three processes we can see of this misrecognition. The first is a general practice of cultural domination and oppression. A second is there's a pattern of non-recognition, which is the equivalent of being rendered invisible. And the third is there's a disrespect or being routinely maligned or disparaged in stereotypical public and cultural representations. Now, we can all think about these types of misrecognition. We see it in evidence of Indigenous peoples and minority groups. But we also see it of environmentalists when they are disparaged as greenies or nimblies or ginger groups. In putting those labels to them, they are downplaying their importance. Can we see misrecognition of non-human nature? The answer is yes, we do see it. And so non-human nature is maligned and disrespected in both social and political realms. So, for example, if you looked at climate change, Schlossberg examined how there's a misrecognition flowing about the issue of climate change. So there's a domination of nature by the mining and extractive industries. There's an invisibility of the nature that is affected by climate change in political planning. And there's a disparaging of the natural world in discussions of the mitigation of impacts on human communities, but all at the expense of nature. So how might we try and overcome that? Could we have more meaningful involvement of non-human nature in environmental policy making and decision making? Well, one way we could do it is entitle non-human nature to be the recipients of the distributions of the environmental goods and bads, and by having regard to the needs, the interests, the vulnerabilities, and the integrity of non-human nature. And the means by which non-human nature can be afforded such recognition include this use of proxies or trustees or guardians and spokespersons. So now for conclusion. Achieving access to environmental justice requires a holistic and comprehensive approach, tackling the institutional, political, social, economic, and legal factors that impede equal justice for all. And only by achieving justice as recognition, procedural justice, and distributive justice can we actually achieve the overall objective of access to environmental justice. Thank you.